Yes.
Item number 7, Your Lordship.
Item number?
7.
Wait for your turn. You will call out.
Item number 7 to 8.
Yes. Now you can mention.
Bearing case number MC 45 by 2025 and IA Civil 3159 by 2025. Seek for adjournment today.
Item number 7.
Look, this is with regard to the question involved whether a private individual or an institution, private institution, can hold lottery in the state of Assam. Now,
You have decided that matter.
no, it's not decided, Milord. There was a representation. There was an impugn order, Milord, due to some legal issue. Your Lordship was pleased to set aside and remand it to the government.
Okay.
But the issue remains open whether.
That's right.
But the
She wants time on behalf of
And Dubey, Mr. N. Dubey.
for the petitioner applicant for whom?
applicant.
As prayed for on behalf of the applicant. And agreed to by the council for the respondent.
Auto station, Your Lordship.
Re-notify on. So.
Look, may I just make, I'm sorry, may I just make one prayer? Till date, Milord, the stand of the state government on the issue is not there by way of filing an affidavit.
You mean, on the next date we'll see.
Fine, Milord. File.
Someday.
28th July. 20. From item number 9 to 21. Adjournment request.
May it please, Your Lordship.
Yes.
I beg to mention item number 13, Lordship, with the consent of the other side, Lordship. My
0.
1-3,
1 3. 13.
Lordship.
Garage. You're for the appellate.
Respondent.
I am for the
As prayed for. You have to pay that amount which is due to the garage owner. Yes.
Lordship. My senior is in personal difficulty today, Lordship.
All right. As prayed for on behalf of the respondent. And agreed to by the council for the appellant. The matter is adjourned to
24/6.
24/6.
Of Lordship.
From item number 22 to 28.
But with regard to item 26, I am seeking some accommodation.
Item number 26.
Yes, but I represent
PIL.
9, 10 in 11. Yes. The state has filed its response.
As prayed for on behalf of response number 9 to 11 by Mr. R. Dubey, learned advocate. The matter is adjourned to. You have informed the other side.
Yes, I have taken consent.
All right.
26 June.
Wait, please, Your Lordship. Item number 20. Wait, please, Your Lordship. Item number 28, Lordship. I have taken consent from the appellant side, Lordship. I am appearing for BTC authorities, Lordship. Instructions awaited, Lordship. Kindly allow us 2 weeks time, Lordship.
Have you taken consent from
From the appellant side, Lordship.
You are for the?
BTC authorities 1 to 8.
Taken consent from Mr. Chaudhary. Is he at?
Lordship, this council I have heard from.
We have no objection.
As prayed for on behalf of the respondent and agreed to by the council for the appellant. The matter is adjourned.
22/6.
Obliged.
Any other request?
Hey, please. Milord, I seek your Lordship's indulgence to make a prayer for listing for read appeal on Monday. In fact, Milord, what has happened? Milord, I have brought on record the certified copy of the order. The read appeal, Milord, which was filed without the copy. Now, on the last occasion, Milord, your Lordship was pleased to fix it on 15th, Milord.
Tuesday.
In fact, Milord, after 4, Milord, my repetition will become infructuous because
What happens?
due to the model,
To election.
Milord, due to the model code of conduct, perhaps they are not, Milord, have not made any appointment. So that option is still open. I'm deeply obliged.
Daily list for orders item 1.
May it be your Lordship. My lord,
Service report as the respondent number 3 is awaited.
And in this case, my lord, I am going to file the Kalapama today itself. my lord.
On behalf of respondent
Yes.
three,
331 and
31 days delay. Are you really interested in contesting this? No. Mr. So-and-so has a there is an application seeking condemnation of delay of 31 days in preferring the appeal. Take the detailed order from so-and-so has appeared on behalf of respondent number 3. Who appears for us?
1, 2 and 3.
Appears for
2
respondent.
earlier already.
1, 2 and 3. You appear for 2 also.
Yes, 2 earlier one at time.
Mr. R. Islam, learned advocate has appeared for response number 1 to 3. The other respondents also do not have any objection to such prayer. Take the order from the delay is condoned, the appeal to be processed and be listed preferably also.
Much.
15th July. Item 2.
As for office to 16/3/2026. Service on the response has already been completed now.
Yes.
And last affidavit has already, it is for the admission now.
With the service on respondents being complete, the matter be listed for mission on your date.
But it, my name may be reflected in the
The name of Mr. Tafildar learned advocate appearing for respondent number for the sole respondent be also reflected in the cause list.
23/6. Item 3.
All these are just don't speculate on them. Yes.
172 days.
Service is complete. One more time we will come. What is the delay? 172. 172 days.
172.
Again, despite service of notice, nobody has appeared on behalf of the respondents, giving one more opportunity to the respondents to contest this case. The matter is adjourned. Give a date. On that day, if nobody comes, we will condone the delay.
15/6. Item 4.
Take this. For non-procedural business.
Item 5.
May it please your lordship, my lord. My lord, I am happy to inform my lord that the order has been complied with, my lord. And he has been allowed to join.
This is item number 5.
My lord.
Mr. Mr. B.K. Das, learned advocate for the petitioner summons that the order question has already, the judgment order, the question has already been complied with. Hence, he does not press this petition. He does not press this application. The application is dismissed as not.
Marvelous.
Item 6.
Yes,
Then it's a delay application by 844 days. On merits, my lord, if the order passed by the learned single judge is allowed to stand, then anybody, my lord, appointed or engaged in any state establishment will be
if it was so
entitled.
serious, why did you delay?
My lord, there were correspondences between the Home and Political Department, that is the employer, and the Finance Department. Lordship will kindly consider, my lord. We have sufficiently explained the delay, my lord, in our.
There is no explanation, Mr. Bapujari.
My lord, how the files have progressed, my lord, how the.
No.
case have-
ground reasons as well.
These are there, my lord,
No
otherwise.
good ground. We checked it.
So,
8. Item 8.
This is the responding number of which will be taken in the original.
May it please your lordship.
Yes,
Lordship, we have filed IA number 12024 for correction of cost title, Lordship. Cost title of TIL, Lordship, which was disposed of, Lordship.
We allow the application. You are permitted to make necessary correction in the cost title. And you'll have to file a fresh memo of parties within a period of 1 week in the registry. Correct? Application allowed.
Item number 9.
21 days delay in filing the.
Yes, Mr. HR Chaudhary does not oppose. Yes, Matikna. He appears. The delay is condoned. The election style.
Maybe because suspension, my lord.
Appeal to be processed and listed preferably on censor.
22-6.
Obliged.
For admission, item 10.
It's a hard case. I think Lordship should examine this matter.
But why? Tell me, Mr. Chaudhary.
But the question is, my lord, I could not apply because I was overrated. Now that post is,
That's much later.
that post is still continuing. No, my lord. In 2017,
Principally, has the single judge gone wrong?
on one count, my lord,
What?
that, my lord, that the post is perennial, my lord, it's continuing.
Maybe, but then
No, my lord, it's an welfare state, my lord. The employer,
you could have made an application. And you could have come to the court with a prayer that there should be age relaxation without passing the test, without appearing
no,
in
my lord,
the.
age relaxation is again, my lord, an issue to be decided by their policy. There is no policy.
There may not be any policy, but considering the fact that you have served, you have been in the pipeline project for such a while. But can we do something which is legally?
I was only wondering, my lord, whether, my lord, in view of the latest series of judgments authored by
It
Honorable
is not
Justice,
like you Jago and all
no,
the
all
cases.
these judgments, my lord, are these not exploitative appointments, my lord? Because when you know this post is required, why regular selection was not made?
You're
It's
not
not
a-
that I have been picked up from,
Mr. Chaudhary, are you a Safai wala? You're not.
my lord. End of the day, I was,
Unless you come out with some special kind of an argument that the principles in Jago should be applicable.
exactly,
Also,
that is my
because
own,
it is very exploitative and all that.
in fact, that is my only argument, my lord. That's my only argument, my lord.
Our hands are tied, Mr. Chaudhary, but on your insistence and considering the fact that this officer,
Huh.
Ranjit Kumar Niyog,
He's an aged person, my lord. Where he will go now?
को देखते हैं एक बात. We'll not discuss it today. Let's. This application is admitted. This appeal is admitted for you. This matter. First paragraph. This appeal is directed against government protection. As a legal. We have heard Mr. Kamal and Chaudhary, level senior advocate for the appellant, and Mr.
I'm A. Sharma for Oil India Limited. That's corner number 228.
So for Oil India level. Next. The challenge in this appeal is to the judgment dated so-and-so passed by a learned single judge of this court in WPC number so-and-so, rejecting the claim of the appellant for being regularized in service. Next fact. The appellant is a mechanical engineer who has been working on a contractual basis for All India Limited for several years. He has been associated with pipeline related projects. Initially, he was hired for a year in
2007.
in the year he was hired for 1 year in 2007 on the for pipeline expansion project However, his engagement was repeatedly extended because the project could not be completed.
By entering into separate contracts every year.
Just a minute. We are not doing anything today. Did you not hear the observations of the bench? But we'll examine whether this could be extended in view of Pritipal, in view of Jaco and others. Because you see, we can't have a very restrictive approach. And you have been taking help from him. You have been using his services and you acknowledge his dedication. So it is worth arguing whether we allow or not. That's something different.
Correct,
What did I say? Please don't interfere in between. Yes, what did I say?
Already engagement was because that was completed.
As also for the reason of his dedicated performance. He has also performed his duties at positions which partake of a permanent character. Despite this, Mr. Chaudhary contends that the appellant was never absorbed into regular position. In the year 2017, respondent Oil India Limited, bracket OIL, advertised permanent grade C post but the appellant could not apply for that post because of being overage. However, he met all other eligibility criteria like qualifications and experience. The major contention of the appellant is that in the first instance also he had joined after facing an interview and medical checkup. No doubt in the contracts which were renewed with breaks, there was a stipulation of no right to regularization. Nonetheless, because he had been entrusted with critical and perennial tasks like pipeline maintenance and gas/oil transport, essential for the oil's preparation, oil's operation. There was legitimate expectation that he would be absorbed in regular service, or at least he would be given age relaxation, keeping in mind his long tenure with the respondent company. The learned single judge did not agree with the contentions of the appellant. Solely for the reason of the appellant being in contractual appointment, being under contractual appointment, with positive disclaimer towards regularization. The learned single judge also was swayed by the fact that there were breaks in the contractual appointment, which admittedly were deliberate. The reliance of the appellant on the decision of the Supreme Court in Jago versus Union of India and others, 2024 INSC 1034, was also specifically rejected, holding that the facts in that case concerned Safai Balas who were appointed on ad hoc basis and had continued for a very long time. The facts of the case, according to the learned single judge, is different from the case of the appellant, where the appellant had served on contractual employment based on different contract agreements containing specific terms and conditions of service. The learned single judge concluded that the service conditions of the appellant would be strictly governed by the terms of the contract. Mr. Chaudhary, learned senior advocate for the appellant, submits that this smacks of the exploitative nature of exploitative way of treating an employee who, for all practical purposes, has served as a permanent employee of the oil India, who deserves either to be regularized or be given one-time age relaxation. The expostulation by the learned counsel for the respondent, however, is that pursuant to that advertisement in the year 2017, the recruitment process was concluded. Mr. Chaudhary, however, contends that the post still remains vacant. The application, this appeal is required to be heard. Admit, list this case for hearing on sometimes in August. Of like
4th of August. Item 11.
Before I start, I may be excused to mention one item 19, my lord. Your worship fixed of 22-6, my lord. Can it be I have taken consent of other side? 22-5, my lord. Item. I may be excused, my lord, because already under suspension for a long time.
Little early. You want an earlier date?
My lord, only for admission.
Where is the lawyer?
Yes, he is here.
I will propose the date. Consultation. Sometimes in May.
My lord, obliged to us. I'm sorry, my lord.
18 May.
Yes, Mr. Chaudhary.
Yes.
Item 11.
Your worship, can you see your worship order?
We accept one plea of an advocate. There are every chances that the other plea shall be rejected. Yes. Yes.
Yeah. Your worship order, last order, madam, they ultimately they wanted to file and they did it. But in fact, madam, in this second suspension, 90 days also over. 4 months already gone, madam. And your worship, kindly see the order of the line, a single bench, my lord. Why did they have 90 days, my lord, and now 4 months, my lord, 4 days, no? 10 days. 10 days.
Have you filed your affidavit?
Lordship, extra copies not served on us, so we not
No,
send the copies, Lordship, and Lordship, JD is the main party, Lordship, their name not shown in the copies.
You should have done that. It was only adjourned for because there was a contention on behalf of the state by Ms. Sumitra Sharma that a detailed counter affidavit would be required. Prima facie, we are not inclined. Prima facie, we are not inclined.
Lordship,
Right, madam, your worship.
JD is the main party, Lordship, kindly, next date, Lordship, in their name, Lordship.
Madam, my only thing is, my lord.
All right, the issue can be argued.
Yes,
Let us see whether deemed suspension under 6(2)
my lord.
and another suspension for the same very charge under
Same very charge.
6(2)(c)
Yes,
Commission being different, whether it would be taken as second suspension and whether Ajay Chaudhary would apply. Ajay
Yeah.
Chaudhary would not apply. That's
But
for sure.
if you
Then
take
the
it-
matter can be argued.
Mm.
You file your response. As prayed for on behalf of the
One-
council for the state. As prayed for on behalf of respondent number 2, the matter is adjourned to give a date in May.
They are already 4 months already gone second suspension. Here, Ajay Chaudhary makes all night.
See, they are perfectly entitled to our mind unless you argue something else.
Yeah.
Because that decision, that power, that leeway, the disciplinary authority, the appointing authority has, especially when the disciplinary proceeding is underway.
No matter what is the intention suspension, matter, he was posted in another office, madam, other office, not in the same office also, madam.
We'll see you argue on the next.
Lordship.
Only
25-5.
25.
Prior Lordship, since GAD is respondent number 1, Lordship, GAD shall be shown in the cause list, Lordship.
GAD.
GAD.
There is any standing
Government, ultimately government.
Now,
Anyway, you informed. Don't worry about it. So next.
Item 12.
Madam, 25, I am sorry, madam. 25, madam,
18th.
I will not, 25, 5, madam, no?
Yes.
Obliged. I'm sorry. Again, I am Mr. Madam.
Item 12.
Yes.
Lordship, this is an appeal preferred by the state.
Yeah.
Lordship.
We'll have to issue notice there.
Yeah, yeah.
Without notice, we can't do, no?
Yes, Lordship. One caveat was there probably, the limitation has already.
Let notice be issued to the respondent. On how many of them? 771.
Seventh, one in, the appeal has been preferred in one writ petition, Lordship. There are other writ petitions. as well.
All right, they all will be governed by what we decide.
Association is there, Lord. So.
Correct. This appeal arises out of this case arises out of termination of 771 contractual employees working under the Assam State Transport Corporation Limited / the appellant. Next paragraph. The employees were engaged between 2013 and 2020 on a contractual basis in various posts. By an order dated 30/5/2023, the Chief Personnel Officer of Assam State Transport Corporation released all the employees from service with effect from 31/5/2023. Next paragraph. Agreed by this mass termination, multiple writ petitions were filed before this court. One of such petitions was filed by the State Transport Workers Association in a representative capacity. The rest of the petitions were by individual employees. The next, the contention of the appellant, Mr. Naik led an additional advocate general hearing for the petitioner, for the appellant. Assam State Transport Corporation and others last period. Submits that though the contention on behalf of the respondents before the court below, before the learned single judge, was that though they were contractual employees, but they were appointed through selection process involving interviews and had been working for several years. Their services were essential for the functioning of the corporation, and their sudden removal would disrupt the operations of the corporation. So in fact, they pointed out before the learned single judge that in a review meeting of the government, it was held
On 27/6/2022.
it was held that the appointments were regular. Appointments were irregular because of lack of proper recruitment procedures, such as advertisement. This was not their fault. And based on this only, the authorities had decided not to renew their contracts and to release them. Which action was arbitrary and violated their fundamental rights. They at least required a show cause notice or an opportunity of hearing before termination of their services. The other ground of challenge was that according to their information, the corporation had been contemplating to engage workers through outsourcing agencies, which in fact would amount to replacing one set of contractual employees with another. Something which is not permissible under the service law. It was also pointed out by the respondents that some of the similarly placed employees were allowed to continue while the respondents were removed. While assailing the judgment of the learned single judge, who has directed that the respondents ought not to be terminated abruptly, considering the shortage of manpower in the corporation. And that they be reinstated and allowed to continue in service until regular appointments are made on the posts. Come on, Mr. Naik has submitted. Mr. Naik, what did I say? How did I begin? Mr. Naik, learned additional advocate general, has contended that the appointment of the respondents were illegal from the beginning, as it was made without any advertisement or any proper selection process. And as such, those appointments are to be treated as null and void, which cannot create any right in favor of the respondents. But that apart, it was urged that the contract of the respondents had already expired. A policy decision had been taken after due verification about the initial appointments being not legal, not to renew the contracts. Mr. Nayak has also denied the apprehension of the respondents that the corporation is contemplating of replacing the respondents with another set of contractual employees, except for limited outsourcing for specific purposes like security service.
Yes, sir.
This was your stand before.
And so far as the judgment is concerned, Lordship, herein, Lordship, all the issues has been decided in my favor. But ultimately, conclusion is against me, Lordship. If Lordship permits, Lordship, only two paragraphs of the impugned judgment I'd like to read, Lordship. Paragraph 27 and 28.
It was further argued by Mr. Nayak that even though the learned single judge held that the appointments had been made without advertisement, but declared them to be irregular
Yes.
rather than
Illegal.
illegal.
That is one, Lordship. And
Let
second,
go.
one more point only, just one point, Lordship, because if Lordship comes to.
Doesn't matter, we are not concluding it today, we are issuing notice.
Yes.
Let notice be issued to the respondents on steps being taken by the appellant / corporation within appellants / corporation and others within a period of 2 weeks.
Well.
Both modes returnable on first week of August. In the meantime, we are not saying anything.
Lordship will do me that favor, Lordship. I'm paying for stay of the operation, Lordship. Why, Lordship, I'm paying for, Lordship? Just one paragraph, Lordship. Lordship,
We can give you a date, you just serve them, we are not going to.
Lordship will bear me
See,
1 minute on.
it is not-
1 minute.
Mr.
1 minute.
Just a minute.
Lordship.
It is not a contract for 1 year. The court has directed to reinstate them in service. It is without any specific contract, only by virtue of the court's order. Let them come, we will decide accordingly.
Court
interim.
directed to take back. Lordship will just 1 minute, Lordship. Lordship, on the last day of hearing, Lordship, a specific instruction was placed on the direction passed by the court, Lordship, as regard the status of the positions held by the petitioners, Lordship. And it was clearly stated that they were never engaged against any post, Lordship.
Before that, let it come. We don't want to sort of, even if we allow your appeal and set aside the judgment of the second judge, it should be in the presence of the employees who have gained that, who have earned that judgment, rightly or wrongly.
But only difficulty will be if posts are not there, Lordship, where we are going to engage them, Lordship.
Let's see.
And if the posts are not
Yeah.
there is no question of regular appointment as well.
That's all right. They have not come for any contempt. This is your stock difference.
Yes, Lord.
A state difference rather.
They have filed.
Not a stock, but a state difference rather.
Lordship, in the meantime,
Nothing.
they have filed 3 contempts in the meantime, Lordship.
We'll see.
Lordship will protect me till then, Lordship.
No, we'll
Till
see.
the next date, Lordship.
The contempt will come before us, before that court.
No, before.
The regular defense would be that the appeal is pending, notices have been issued. Don't ask us to do something which is not legal.
Lordship will observe 1 line to that extent, Lordship. Otherwise, Lordship,
Yes, next.
where is the 5-8?
Not necessarily being apprehensive of something. Nothing is going to happen. We have taken notice, we have issued, we have taken cognizance of it, we have issued notice to the other side. As far as possible, let them remain in service, pay them for the period that they work. Ultimately, we'll decide what will happen.
In the meantime, they have not been taken back, Lordship.
They have not been taken back, then we will see what is to be done. We'll see what is to be done.
No, Lordship, we will at least
not
understand my dilemma. There is no as post as such.
We are very, very careful in doing it. We will not take away that right, especially these contractual employees in the interregnum. We will decide the matter.
Item 14.
Doesn't matter. And wherever your notice for contempt, tell the court, tell the single judge that appeal has been admitted. Notice has been issued.
Yes, next. Yes. Oblige.
We have also been on that side, no? That apprehension is useless. Nothing is going to, nobody is going to hold you up for contempt. But Forget about the notice. Even if an appeal is filed, normally 2-3 chances are given in contempt petition. I don't know what is the procedure here. What the single judge-
I appear in the contempt. I will not insist. Your lordship's order will remain. I'll not insist. I'm appearing in
No,
the.
even if you that your right still to.
Obliged.
My lord, so far the judgment of the learned single judge.
Which matter?
My lord, it's again, the impure order is at page 43.
No
Well-
payment because of latches.
Yes, my lord, but what has happened on day one, without waiting for the affidavit or the claim of the government against non-payment, because in the other case, my lord, the government has said no dues.
Mr. Kumar, but the money became due to you sometimes in 2010.
Yes, yes, ma'am. Absolutely. If your lordship looks from that angle, I may be termed as Rib Van Winkle, I may be termed as Kumbhakarna, I may be termed as I have a person who has slept over my head.
Red Van Winkle rose from his slumber after 20 years.
Yes, ma'am. Yeah,
This is
so.
only 12 years.
12. But what has happened, my lord, same work, same contract, this court asked the government to file the affidavit. And when the government filed the affidavit, in cases where the government has admitted that yes, dues are there, they have been paid. And where in cases where there is a stand of the government that no dues are paid, then the court did not ask them to pay. The connected matter is there, we'll file a rejoinder. My lord,
Hey, no. We have heard Mr. B.D. Kumar, a senior advocate for the appellant, who has questioned the judgment dated so-and-so passed by a learned single judge of this court in WPC number so-and-so, deny to interfere and direct for payment of dues of the appellant at the motion stage itself on the ground of latches. Stop the money due to the appellant, the work as next. The appellant is a registered government contractor whose services were utilized by the Water Resources Department of the Government of Assam. He was entrusted with the responsibility of completing multiple works under various work orders under an urgent scheme to protect river embankments in Assam's Dhubri district, which project was funded by the Central Road Fund. Despite his having completed the works on time, while adhering to all specifications, he had received only partial payments. The contention of Mr. Kumar is that the full final payment of approximately rupees 19 lakhs and odd was withheld for over a decade. Perhaps for bureaucratic delays. There were verbal assurances from the functionaries of the department. And precisely for that reason, the appellant approached this court only after how many years?
12, 15 years.
Only after 15 years.
But there's a liability certificate of 2022.
The learned single judge dismissed the writ petition preferred by the appellant, citing delay in latches since the contract work was of the year 2010. The no liability certificate also was found to be not so reliable, even though it was of the year 2022.
22.
22 to allow the claim of the appellant. The appellant was, however, given the liberty to file an appropriate civil suit for recovery of money instead. The major contention on behalf of the appellant today is that the petition not to have it dismissed at the motion stage without any confirmation / a settlement of the dues of the appellant. Let notice be issued to the respondents on steps being taken by the appellant within a period of 2 weeks, both modes returnable July and August.
Deeply obliged. Item number 28 also 27 is also relating to the same matter. Both this matter may come up on August.
Let item number, let the case be listening along with. This is item number
14.
14. 27 will file a rejoinder. It's relating to the same that area war.
27.
Next page.
Along with, you're the same person, Manzoor Alam.
No.
No, different person.
Different.
In this
Same
case, we file our affidavit.
We'll file a rejoinder. Both this matter come up together. There is a. Oh. No problem. We will get.
On 29/7. Item 15.
Similar.
Yes, Lordship, but we are in a very vulnerable condition, Lordship. We are on the river bank. So at the season, we know, Lordship, we are in a very vulnerable state.
Mr. Goswami?
We have received some instruction from the district authorities, but that will not suffice. I need some instructions from the chief secretary. I will kindly appreciate one thing. Anybody encroaching inside a forest.
No, we have followed.
That's fine.
We are not.
Ms. Ghosh is not saying that she has a right to stay in a forest area. Is she saying that?
Yes.
The entire petition is structured on a different thing.
Yes, ma'am.
See, your welfare state, they have been
Exactly.
living there for a long time. That does not give them any right to encroach upon the government land, especially the forest land. They have to be evicted. No difficulty. But she wants an accommodation. She is giving no choice.
Usually we provide food and shelter for 3 months. Then they can apply under land policy.
Another aspect is you have a policy that
Land
no
policy.
person will be homeless. You are having policies of giving.
Yes, ma'am. For that they have to make an
And
application.
all. So you have take some
Yes,
instruction. It's a rainy season. They are in the bank of
River bank.
River Bank.
Mr. Patnam.
Where is Mr. Nath?
Mr. Parangam.
My lord.
Mr. P.N. Goswami, learned senior advocate and additional advocate general. Now, we are referring to all such newly designated senior advocates whenever they appear, along with the designation also. Because for the first time, it must come in the order sheet of the court. Mr. So-and-so P.N. Goswami, learned senior advocate and additional advocate general of the state of Assam, seeks some more time to take instructions in the matter and respond to the petition. Is this matter on after 2 weeks?
My lord.
Deep view.
Constitution 16. Item 16.
Guys, what are you going to argue in this case?
Yeah, let's see, you'll see. Petition,
Argue in this case unnecessarily.
my lord,
Where is the dispute with respect
your
to
lordship
that?
will kindly see a advertisement, your lordship.
What advertisement?
Advertisement regarding the post, your lordship. Page 17, your lordship.
गलत है, cost लग जाएगा आप पर. You can't argue against law, can you?
Because there's a poor lady, there's a
Old lady means what?
poor
Old
lady.
lady, so you have accepted brief from her. And I'm sure it is not a pro bono thing. You certify that this is a pro bono litigation, we will not impose cost. Yeah, the advertisement itself says that it is not reserved. So an OBC candidate who is more meritorious than you, she entered the job. So what is the question?
But
You are anticipating that because the advertisement, just gave a dash.
dash mark in it.
So
So what does it
nothing
mean?
has
I
been
don't
filled up.
understand.
So
The
what?
dash mark, what is dash mark is the,
Mister, you said that the lady is poor, she is.
that has
asking
been
for a
mentioned.
job as an
Other post
Anganwadi
you will
worker.
not, you will
Therefore,
not.
we are restraining ourselves from not imposing cost.
Yeah.
Otherwise, at least token cost should be imposed to be paid by the lawyer. Why have you advised this kind of an appeal?
Other
Withdraw
post,
करिए नहीं तो मैं आप पर cost लगाऊंगा. What kind of advice have you given? Have you given?
as you Lordship will find, I don't.
Unnecessary. It's not even worth the pages and the ink that would be wasted in the judgment or in the order. Therefore, we are asking you withdraw this. I mean, we take notice of these difficult situations wherever we require. But this is, I mean, we'll have to record that knowing fully well that it was an open competition where there was no reservation. And there is no doubt that the respondent, respondent number six, respondent number six had obtained more marks. She has been given appointment and you have advised her to file an appeal on the ground.
Regarding that earlier, your Lordship, I have moved one case, your Lordship. Then there is
आप
a,
record करवाएंगे हमसे something against you unnecessary. Anyway, we will try not to do that, but let us dismiss it straight away. We have heard Mr.
RM Chaudhary.
Mr. So and so learned advocate for the appellant. The appellant, a general category candidate from local economically backward background, had questioned the appointment of respondent number six as an Anganwadi worker at Kalzar 3 location. At Kalzar-3,
Kaljar.
Kalzar-3 location. The advertisement against which the appointment was made was not limited to any, was not circumscribed by any reservation of the post. Meaning thereby that it was an open competition. So respondent number six scored more marks than the appellant. The contention of the appellant is that since it was an open competition, she should have been accommodated as a general candidate and not respondent number six, who hails from OBC category. We must say the claim of the appellant is based on no ground whatsoever. The learned single judge rightly rejected the contention of the appellant. But for the economically straitened circumstances of the appellant as claimed by a lawyer, we would have imposed cost on such frivolous litigation. However, we restrain ourselves from doing so. The appeal is dismissed. You should have withdrawn it. When we had asked you, when we suggested to you, you should have withdrawn it. We normally don't ask advocates to withdraw their cases and we decide this way or that way. But this was something which is against law. You're an advocate. You should not have advised. In fact, you should have argued and you should have taken the order for your benefit, I'm saying. You should have taken an order that after some arguments, Mr. So-and-so seeks permission to withdraw this. Try and follow what the court advises you. Chill.
Item 17.
You don't interfere in the situs locus of the Panchayat Bhavan.
Yeah, please, Your Lordship.
What kind of PIL is this?
This is
What
File
kind of
against-
PIL is this?
interference against the act of respondent for laying foundation stone for construction of Chandinagar Gaon Panchayat building.
अरे उसमें से पढ़िए मत आप.
Lordship, this is basically filed because
Who reads you in this matter?
AR Sigda.
Mr. Sigdar will be questioned by this court whether a PIL, whether this qualifies for a PIL.
This is a fit case, my lordship may impose cost, my lord.
अब इनको क्या करना है ये तो he was reading from his brief from synopsis. Ask Mr. Sigdar to come and ask him that the court has advised him to withdraw this petition. Unnecessary PIL for the location of Panchayat Bhavan. You people would not allow any Panchayat Bhavan to be constructed.
Lordship, grievances is
This
that-
is what grievances. The decision
The
is
land
taken
that is
after,
proposed-
consulting all stakeholders. And whichever place the government, the guidelines of different state. I mean, in the state of Bihar, we know the land is made available. There are certain guidelines with respect to selection of site. All this would have done. Where is your allegation that despite this, in the headquarters, it has not been constructed? Only convenience. Convenience for you. And this is public interest. How has the public, that vetting committee has cleared it? Mr. We would have otherwise dismissed it today. We would like to hear Mr. Sigdar. Have you followed what we have said?
Yes, Lordship.
Tell him that this was the view of the court. Next day he should come and withdraw this. As prayed for on behalf of the petitioner, re-notify after 3 weeks. Unnecessary.
Highly obliged, my lord.
22nd May.
Obliged, Lordship.
Item 18.
Yes, who appears? We don't want your assistance today. This is again a case of that kind. Some fire in private kitchen.
Yes, Your Lordship, the objection was also filed in ground. Unnecessary.
What disaster is this? What disaster is this? Anyway, we will not dismiss. Well, nobody appears on behalf of the appellant from repeated calls. The counsel for the, you appear for the state.
I'm for respondent number 2, SC rating unit.
The counsel for respondent number 2, however, is present. Let this matter come up for consideration again on August.
Obliged.
3rd August, 3/8. Item 19.
My lord, here,
Yes,
my lord, here issue is, my lord, that whether the petitioner, appellant is entitled for, my lord, old pension scheme and or new pension scheme.
you have been regularized when?
My lord, I have been regularized on 31/7/2006 pursuant to an order passed by this honorable court. My lord.
So the posts would have been vacant and would have been sanctioned only prior to your regularization.
Yes, my lord.
But your services on an unsanctioned post would not be counted for.
No, my
pension.
lord. I'm sorry, my lord. Post was sanctioned in the year 1995 itself.
How do you say so?
My lord, kindly come to page 35. My lord. 35, my lord. 35 is the annexure 1 of the petition, my lord.
Page 35.
Yes, my lord. And in the regularization order itself, it is reflected. I was appointed in the law division assistant, my lord, in the post of law division assistant.
Sanctioned post. How come the legislature judge just said that it was not sanctioned?
My lord, that is, my lord,
Let
unfounded.
notice be issued. Who appears? Mr.
I appear for 1 and 2.
Mr. Barua, respond to this petition. There is a factual mistake in the improved judgment. Of course, he still has a weak right to pursue. He was regularized only from 2006. You have to respond to this. There's a factual error in the single judge's order. Page 35, it's a sanction post.
I think at least only 1 and 2, 3 and 4.
Again. The appellant questions the position of the respondents in bringing them under the new pension scheme on the ground of their services having been regularized on 31/7/2006 only. The contention of the appellants is that they had been serving for long against sanctioned vacant posts through regular appointment. Mr. Paruwal and counsel for respondent number 1 and 2 seek some time to respond to this petition. Mr. Let the requisite affidavit on behalf of response number 1 and 2 be filed possibly by the next re-notify August.
5th August, I will. Yes. Item 20,
In this case, I have received the instruction yesterday evening, ma'am. I allow you 2 days time, I will file again.
You have deposited 10 lakhs rupees?
I could not, my lord, I could not arrange the money, my lord. Here, the, my lord, nutshell is the point is that, my lord, that the license has been issued under the old rule. Now they are claiming
Doesn't
on the,
matter. Doesn't matter with the base fee across board.
my,
As you made. Now that has to be questioned. You
Yes.
can't ask for yourself.
yes, my lord.
Unamended that, they will say that it was under the unamended rule. Therefore,
Yes.
this license is bad. They'll withdraw the license. What will you do then?
My lord, in that case, therefore, my lord,
And
for side,
these are Mr. Counsel.
yes,
You are Mr. Das.
yes,
Mr. Das, these are rest commercial matters.
that's right.
Nobody do not interfere.
The limited
Rest
ground.
commercial. आपकी बिजनेस करनी है, आपको ऑनलाइन शॉप में शराब बेचनी है और आप पैसे देने से मना कर रहे हो.
My lord, my client, my lord. My lord, therefore, I have challenged this, my lord, into an
As
amendment.
prayed for by the learned additional, I, Mr. P. N. Goswami, learned senior advocate slash additional advocate general, re-notify after 2 weeks.
Obliged, my lord.
3rd June. Item 21,
Yes, Mr. Sharaf.
But I'm challenging the validity of the one rule of the act. Now, in fact, my lord, the cess was imposed.
Which rule, which act?
Well, I'm just giving the rule of it. Yeah, the act is, my lord, the HNS says legislative, this one, Act 25 at page 51.
Health Security and National Security Cess Act of 2025.
My lord. Section.
Where do we find it in your petition?
My lord, it will be, you also find at page 51.
Okay.
Section 4. You'll also can see at page 53, section 4.
This legislation, this Cess Act was brought when?
The cess act, my lord, was brought into force.
16th of December 2025.
My lord,
Yes. Let us see first the
page
purpose.
page
Act to augment the resources for meeting expenditure on national security and for public health and to levy a cess for the said purpose.
I'm not challenging the provisions of the act.
Then what are you telling?
I'm challenging the provisions of rules, my lord.
Roots.
My lord.
Now let us see. No, we must know the purpose.
My
for
lord, my
bringing
lord,
this
my
Cess Act.
lord, my lord.
The purpose is meeting expenditure on national security and for public health.
My lord.
to levy a cess for the said purpose on the machines installed or other process undertaken by which a specified goods are manufactured or produced and for matters connected therewith or incidental thereto.
My lord.
So this is national security.
National security, my lord, some says imposed, I'm not objecting that, my lord.
No, we must understand the purpose for the
My
imposition.
lord, it says, my lord, the national
But
security.
it is not only public health, but for national
Yes,
security
yes.
as well.
My lord.
So anything that you say, anything that you say, we have not gone through the routes. Now let us see what the challenge, but these two things have to be kept in mind.
My lord, certainly.
National security and public health.
My lord.
Now, this is only with respect to use of machines.
Machines, my lord.
Acha? Now let
Now,
us see the
now also
provisions.
see the charging section is 4. At
Charging
page
section is 4.
4 at page 53.
Chapter 2, health security. What is SE? What does SE mean? Health security, say national security cell.
Say Hindi words, Lordship.
It should be NE, no?
Security says, my lord.
I'm asking
SE.
something else. What is SE?
Say. My lord, it's a Hindi word, Lordship.
Health sec-
Health security से national security से है.
नहीं, वो हिंदी word नहीं है. Mister, don't take a guess. That's a wild guess. वो होना चाहिए health security से national security तक. ऐसा थोड़ी है. It is NE probably. NE. Anyway, that's not our concern. Now let's see.
Next, page 53, my lord.
Hmm.
There shall be levied and collected a cess, section 4, my lord,
Hmm.
to be called health security, say national security cess from every taxable person on the machines installed in the other processes undertaken in by him for the manufacture or production of the specified goods referred to in Schedule 1 at the amount specified in the Schedule 2 and the computed in the manner provided therein.
Hmm.
Now we'll also see section 5, my lord. How the cess is to be calculated, my lord.
Yes.
The sales referred to in section 4 shall be computed in accordance with the provisions of this section based on the relevant process, speed of the machine, or the capacity of the machine, or other provisions, so on and so on. So your also is 2, my lord. Where the,
One second. This cess is not for the installation of machine. It is for the speed of the machine or capacity of other process,
Well, in
and
fact-
weight of the specified goods packed in pouch. We can understand weight of the specified goods packed in pouch, but it is for the rate of the machine also,
Well,
speed of the machine also.
no, my lord, it is not in so. My lord, in fact, instead of the actual manufacture, what they do, my lord, that maximum capacity of the machine to manufacture on the basis of the capacity of the machine,
They collect revenue.
they calculate it.
Right.
In advance, it is determined.
All right.
So whether production is less or more, that is not the concern. What is the maximum capacity? On that basis, my lord, the sales is
That
calculated.
is it. All right.
And I have to, my lord, give the details of the machine to the authority. The authority verifies it by making a local inspection and thereafter determines the maximum speed of the machine. And on that basis, the sales is to be paid.
Correct.
Now, if I, my lord, stop the production for some other, for some region,
That's right. We don't want to know that because you're not questioning this.
I am not questioning that.
Then
But then the rule making power is there, section 35, page 69. I may say in short, what is my challenge?
now first you tell us the power, which section you are referring to.
Section 35, the rule making power.
Rules for carrying out the provisions of this act.
Also, in particular, without so and so, you'll also see it all deals with the the abatement of the condition subject to which so and so, the condition subject to which,
This also is not under question.
not questioned. The only question which I'm making, my lord, in rule 35 is that, my lord, in installation of the CCTV cameras in the entire manufacturing inside and keeping it for 24 months and giving the entire CCTV cameras footage to the authorities.
No, but is it there? Where do we get it?
Rule 35, my lord, I may take your lordship. The rules, I think, 33, page 85. At page 85, it starts with, the rules starts with, my lord, 78, no, 76. 76.
Rule 33.
And rule 33, you'll also find. What is it? Page corner. 85. Page 85.
Yes. What's wrong in it?
My submission for lawsuit that. First of all, it is beyond the rulemaking power which has been given. Secondly, assuming, my lord, for the time being, I assume it, that it is for the prevention of the evasion of the taxes. Although for that purpose also I have great doubt that anybody can say that you give the CCTV cameras, otherwise, my lord, in all the shops and the, my lord, manufacturing processes, hotels, restaurants, all the CCTV cameras will be installed and somebody will say to give the CCTV cameras. But here, since the production is not the criteria for the review of the sales, and it is only the machine capacity, and thereby to installation of the CCTV cameras and giving the footage.
The argument on face of it in the first blush may appear to be attractive, Mr. Saraf. But then it's quite perchance that my gaze fell on the rule-making power under chapter 12 at page 69,
My lord,
section 35,
my lord,
come to the provision contained in J.
my lord.
The oversight, monitoring or verification mechanism to be complied with by the taxable person under subsection 6 of section 9. And now this installation of closed circuit television system is for the purposes of surveillance, covering all areas where the packing machines are installed. They don't say that that kind of, footage would be used for any other purpose. And even otherwise, this cannot be stopped. And this is not beyond.
My lord, I will.
See, the taxing statutes have to be treated very strictly. Without the power, nothing can be taxed. But this is not money.
My lord,
This is not exacting any revenue from.
but
This is for CCTV camera for very many purposes, whether you are tampering with the machine, the
Tampering with the-
rate, speed, whether you would increase, you would lessen the speed, you do everything. This is essential.
my lord, the question I will submit to you. Machines which are installed is in the first very beginning. The machine capacity, maximum capacity of the machine.
How does it adversely affect you? Because
Not
it
adversely
is
affecting-
not, causing any strain on your purse.
My lord, it causes. My lord, I don't want to give the privacy and the materials, how I manufacture and all those things. Because
Now tell me one thing, Mr. Saraf. Now we are not able to appreciate that. This must have a pan-India impact.
my lord, that's why the different high courts are, my lord,
So that is why you tell us if we will go by the logic of the other high courts. Otherwise, we are not prima facie, we are not inclined.
my lord, certainly I will to take time for me, my lord, the convention also because otherwise, my lord, the effect is that, my lord, if these things are allowed,
How does it affect your purse?
my lord, I will say, not.
How does it affect your revenue?
My lord, not in the question of the purse.
No. Privacy on
My lord,
privacy.
in every shop, tomorrow,
Let us see the views of the other high courts.
My lord,
of the
my-
Supreme Court.
113. First order, my lord. Following this, the Rajasthan High Court also, my lord, as part of the similar orders.
No coercive measures shall be done. कोई नहीं ये तो नहीं कर पाएंगे. Will not be able.
Well,
Give us a final decision. We will approve, but it doesn't appeal to us.
well, I mean, just your lordship, kindly appreciate.
We will. I mean, we are only making it difficult for you.
Well,
We are ready to hear you at length.
Don't feel like, my lord, that your lordship's questions. I really enjoy when the questions come so that I can answer. My lord.
Correct.
Well, my view is that, my lord, in a case where production is there, on that basis, my lord, the tax is leviable.
No, instead of doing that, Mr. Sharaf, you would do a better job by telling us any reason doubting the correctness or doubting the utility of this requirement. If any judgment, if any court has decided that it is futile, let alone harmful for us,
That will be only after the final decision.
let it be decided by some other court.
Some other courts on this issue.
Because on this, I have my own view, which is a very strong.
I'm submitting,
We can, if
pan
we,
masala,
if
pan
pan
masala.
masala or any masala, if we can
No.
have everything, visible what happens inside court for grounds of transparency.
No, I'm just telling you, pan masala which in fact is available for 2 rupees also. It is available for 50 rupees also. The same pan masala packet. Now there are certain ingredients which others don't have. I have got. Now I don't want to disclose that ingredients to others.
And you'll be precluded from doing so because it is health security also.
No, health
And
security.
we have some idea
No, health
that
security.
for making it, cess is all right, for making it more, palatable. And
My lord, if this is allowed, my lord, if this is allowed, tomorrow in the gold shop and everywhere they will impose CCTV, make one person sit there in the cash counter. That for the purpose of determination of that, I will ask one person to sit there.
We are stretching it to limits which may cross the line of absurdity. But then I must tell you,
My lord, in taxing statute, I must say, my lord.
In taxing, it is.
My lord, I must say, my lord, certain arguments when we advance before lawsuit, my lord, it may appear to be
taxing statute is all right. Therefore, we said that it does not concern with revenue collection.
That's why, my lord, I'm saying if it is not concerning the revenue collection and national security, if this says, but the purpose of the sales collection is for national security.
No.
The production is for not national security.
We are not getting convinced for this reason that if you say that your secret masala would become public, that can be no ground.
It may be rejected. On that ground, your lordship is not convinced.
No, we will see that whether you are using Burmese areca nuts which are not good for consumption. You'll be using Burmese nuts for give us a reasoned judgment of High Court, we will follow.
My lord, judgment is not there. Rajasthan High Court has followed this same decision, same order.
This is no order.
Same interim order, my lord, the Rajasthan High Court has also passed.
This is no order.
And your lawsuit and the Allahabad High Court has passed these similar orders in 5 or 6 cases.
एक reason दीजिए हमें.
And your lawsuit can be similar. This is an all India statute. Now, all India statute will not one industry which has got an order from the Allahabad, that order will be applicable in respect of that industry in Assam also. But the person who has got the order.
Chewing tobacco, jarda, scented tobacco, everybody. I mean, this applies. You show this order to the authorities.
My lord, your lawsuit can
don't take an order from us.
No, my lord. That question, my lord, your lawsuit just your lawsuit. It is not so, my lord, that my purpose is.
Mr. Saraf, we are for cautioning you. We are for warning you. The views that we keep, it is better that you don't get decided finally by us.
No, I will like that it will be decided by you.
No, I'll be giving very strong reasons.
Your lawsuit, whatever view your lawsuit will take, I try to convince your lawsuit. I'm not running away. That because your lawsuit is taking some adverse view, so I will run away from your lawsuit and will not pray for a final judgment from your lawsuit.
Come up with more reasons.
Well, I will just
make a good formulation for us on the next case. Today we have started with a negative.
Well, I may just make a submission for lawsuit that when 2 high courts of the country on a similar issue have passed the order, and that order which is passed by Allahabad High Court will respect of that industry will be applicable all over the country. Now, if it is applicable for all over the country in respect of that industry, that means wherever they are operating in respect of those industry, it will be applicable.
Should be.
Now, if those industries, if they are operating in Assam also, that it is applicable. And insofar as I am concerned, it will not be applicable. Then, your lawsuit will just see and your lawsuit will see the one judgment, not necessarily,
if there had been one paragraph, one reasoning which would have appealed to us, we would have gone by this.
It depends on the hyperbola. Your lawsuit gives the regions like this. But in all the courts, that is the difficulty.
Kusum Ingots is on a different aspect.
And page 20.
Kusum Ingots is with respect to the jurisdiction.
No, page 22. Just see, if you page 20, para 22.
इसको इससे क्या मतलब है? Why are you showing this? We have used Kusum ingots for territorial, jurisdiction.
I think that government, so far I want to think. If for the purpose that if I file a petition, somebody for the action in Gauhati and in Allahabad, and he files a petition in Allahabad, gets
The company is located where?
this company is located in Assam.
With the head office where?
In Assam, you know.
Nothing in Delhi.
Delhi is not there. Jurisdiction question, Delhi is not there. Now the question is that one
Then why
industry.
are you showing this just? Here, there is nobody who is questioning the territorial jurisdiction of this. The same pan masala ka hai. This, in fact, if you want to have any advantage of this order, you can keep a certified copy of this order and tell them that this is with respect to them.
I am, you are asking, perhaps I will be able to get myself.
So कभी और भी बताइएगा. Today तो I am not inclined.
Well, I'm not saying that this will be applicable in respect of me also. Not, I'm not saying that.
I'm not saying that it will not be applicable in my case, but those companies, they are operating in Guwahati.
Well,
and shall
in
have the
anywhere-
affidavit, so this, therefore, this is it will be a kind of discrimination. That is your argument.
Well, that's why.
That also doesn't satisfy us.
Well, my solution only was there. And two high courts that taken the view and portion will be taken. At least, in my case also that much, at least not staying the operation.
Mr. Saraf, your pleasant demeanor and good arguments will fetch you one order. We will ask them to respond.
Well, again, I may only, I can,
Listen, we are not getting persuaded to pass any order beyond this. Notwithstanding two interim orders by Allahabad High
I
Court.
can only make a submission before lawsuit. Beyond that, I cannot make any submissions.
No, we are not closing the doors.
No, I'm not saying.
We are not closing the doors.
That why?
Some other day when you come,
Why I should be
when you come more prepared, today also you are prepared, when you come more
why I
prepared,
should be
your argument should not be based on page 113. You tell us the reason, logic. We find that yes, it should be. Why not?
Well, only your lawsuit is not staying the provision. The lawsuit only the coercing measures, that's penalty. The lawsuit is not staying the provision of the rules.
That's indirectly staying.
No, not lawsuit coercing measures.
Indirectly asking them not.
Recovery of the taxes, when your lawsuit says that it coercing measures will be taken, I can admit that it amounts to the almost not taking recovery. But so far as this.
अच्छा आप अभी लगाइए camera. So there are penal provisions. You apply camera now. When we decide, we will have it removed.
In my humble submission, again, I will make a humble submission that I may also be.
Understanding the seriousness of it, why we take
in fact, I should, one thing I must say, your lawsuit, when you passing the order, your lawsuit in interim order also, your lawsuit leaving various reasons. So why passing the interim order? But that is not so, in other courts.
Like, Saraf, we would have, let me tell you, we would have rejected your prayer straight away, giving our own reasons. But then we are not doing it for the reason that there is a high court order. Therefore, we must show some deference to the order passed by other high court. But we are sorry to say we cannot go by this order. We can give you, breathing space. You come up with more ingenious arguments. And in the meantime, we'll ask them to respond.
If lawsuits till the next date, if the lawsuit just till the next date, no coercive steps. No, if we would have been persuaded, even this bit, we would have passed that order. Mr. Saraf, you know that. I will not, I cannot, although I cannot say anything,
Yeah, but this is not appearing to be bad to us.
I thought I could also, follow the same order.
Mr. Saraf, it is.
I fully appreciate,
We are not finding.
I cannot make a comment on the order which has been passed by the Allahabad High Court and the Rajasthan High Court, but I fully appreciate.
No, I'm saying something else. We are not finding anything very serious about the installation of camera inside. We are not finding that it is an inroad in your privacy. Rather, with the national security and health security, I think it's a must. My reasoning goes this way.
National security and health security, this case is collected for that purpose. The purpose is not that, the national
to ensure the securities. We are keeping aside this cess part. What has installation of CCTV camera to do with cess?
Two lines below. This cess is imposed for the purpose of contribution towards the national security and health security. This is not connected with the production that the health security, national security is there. Like education says, higher education says, the sales is collected to be contributed for the purpose of the education and the higher education says. That is not connected with the partner industry. The amount will go and expended for the purpose of national security and health security. This amount will go towards that. It's not so that the national security and health security, for that purpose, the industry on that it is imposed. The amount will go towards the expenditure to our national security and health security, but not that the industry which is there. There the question of national security and health security is there. That is not the question, my lord.
We have heard Mr. Ashok Saraf, learned senior advocate for the petitioner, and Mr.
Dr. S. Chetia or
Mr. S. Shetia for response number 2. This writ petition has been filed questioning the validity of Rule 33 of the Health Securities SE National Security Cess Rules 2026 on the ground of same being ultra virus the provisions of Health Security C National Security Cess Act 2025 as also violative of Article 14 of the Constitution of India. The health next paragraph. The Health Security say National Security Cess Act 2025 was enacted for the purposes of augmenting the resources for meeting expenditure on national security and for public health, and to levy a cess for the said purposes on the machines installed or other processes undertaken by which specified goods are manufactured or produced, and for matters connected therewith or incidental thereto. Section 35 provides, Section 35 of the Act of 2025 referred to above provides that the central government shall, by notification, make rules for carrying out the provisions of the Act. Those rules would be for providing facility for many miscellaneous matters for the working of the Act, like abatement or other conditions subject to which the cess determined would be payable, or the activities, schemes, and programs for national defense and security or public health for which the cess may be utilized, or the oversight, monitoring or verification mechanism to be complied with by the taxable person, etc. Next, pursuant to such rule-making power, the central government has framed Health Security, National Security Cess Rules 2026, which has come into force on 1st of February 2026. Rule 33, which is under challenge in the present petition, provides for installation of closed circuit television system. The rule provides that every registered person engaged in the manufacture of the specified goods shall install a functional closed circuit television CCTV surveillance system covering all areas where the packing machines are installed or the manual process units are located within the factory. The recorded footage in that case would be preserved for a minimum period of 24 months from the date of recording. The registered person shall, on written requisition, furnish the recorded CCTV footage to the proper officer or any officer authorized by him, within 48 hours of the receipt of such requisition. Where are the penal provisions?
Well, the penal provision for not consider for not.
Where are the penal provisions?
Well, I'll just one. Do the thing. There is a general penalty provision below. Penalty melody lawsuit receipt, please. Section 61. Rule 19 at 61 below. At page 18, rule 18 below at page 60.
Section 18.
Section 18.
6. Page 60.
Where does it relate to this provision, 33?
No, that is not specifically, my lord, 33 has not been given, the contamination of the provisions of the act and rules. Okay, sir. General provision.
Actually, Rule 32 has also provide for penalty for contravention. Page 84, man. Rule 32.
Rules of that is for
These are all
the
general provisions
general provision.
with respect to non-installation of closed circuit.
It only will say that the fails to furnish particulars.
This is for against non-disclosure or wrong disclosure, because under section 9, 1, 2, 3, all these up to section 6, you need to make certain declarations.
The very apprehension of these petitioners indicate that they would like to do something else. They'll report about a machine which has a low rate and therefore less cess, and they'll replace it with a higher speed.
That is altogether different. No? Only melody it says.
But where is the provision which says that the CCTV camera is
Sections no, it doesn't say specifically in this provision.
But then why this overprotective, anticipatory kind of a protection?
Well,
Therefore, we say that without any reason, such protections cannot be given to such.
fails to furnish information or documents called for by the officer in accordance with the social
Correct. The
rule 19.
only
Section 9.
difficulty, Mr. Sharaf, is that if we give our introductory paragraph while issuing notice, we might disclose our mind that we are not inclined. We will try and not to do that.
Well,
We'll
only,
wait for the other course.
Lordship is only recording the facts, what are there.
But otherwise, we can say, we can conclude it today also, but we will not do that.
Well,
Let me-
I will be culprit for other courts also.
Let me assure you, we will not be concluding it today.
Well-
Yes, can. Yes, the petitioner is engaged in the business of manufacture and supply of pan masala and is duly registered under the goods and services tax regime. It is his contention that pursuant to the enactment of the Cess Act of 2025, a capacity-based cess has been imposed on specified goods, including pan masala, which has been computed on the basis of the maximum rated speed of the machines and packaging parameters, irrespective of the actual production. The challenge to Rule 33. The challenge to Rule 33 is precisely on the ground that the Cess Act of 2025 confers no power on the central government to mandate any surveillance or data retention. The levy of cess under the Act, according to the petitioner, is based on the maximum rated speed of packaging machines and the weight of the specified goods, which are technical parameters verified through physical inspections or perhaps certification by a chartered engineer and expert consultation. Next, the contention of the petitioner therefore is that the requirement of installation of CCTV cameras and the obligation to retain the footage for a specific number of days and produce it on demand perhaps has no nexus to the computation or verification of cess liability. To that extent, it has been contended by Mr. Saraf, learned senior advocate, that such requirement under Rule 33 is not only arbitrary, but is violative of the right to privacy of any manufacturer. Since this requirement is not obligated for other manufacturing units, it would also be violative of Article 14 of the Constitution of India, and in some respect, a breach of the rights of the petitioner under Article 19 of the Constitution. There are some ancillary grounds on which it has been questioned, on which the rule has been questioned, namely the unfeasibility of the retention of CCTV footage in view of power cuts, irregular electricity supply, etc. The core contention of the petitioner, therefore, is that under no provision of the Act and the rules, under no provision of the Act, is there any under no provision of the Act, is there any requirement of installation of CCTV cameras which serves no purpose except invasion of the privacy and an additional burden on the manufacturer? Mr. Chetty, on the other hand, has drawn the attention of this court to provisions contained in Section 9 of the Act, which obligates every taxable person to furnish a self-declaration with respect to the machine installed or process undertaken in any factory. Together with the parameters relevant for computation of the cess, including the maximum rated speed, weight of packing, nature of packing, and other technical or operational particulars which may be prescribed. Next, such declaration by a taxable person shall be subject to calibration, verification and confirmation by proper officer, with the approval of an officer, by a proper officer. And that every taxable person shall comply with such oversight, monitoring, or verification mechanisms, whether technological, operational, or audit based, as may be prescribed, to ensure the integrity and accuracy of reporting in relation to the manufacture or production of the specified goods. He has also referred to the penalty provisions under Chapter 6 of the Act of 2025. Where non-declaration failure to pay the cess failure to furnish information or documents called for by any officer, or furnishing of false information or documents during any proceedings, or tampering of or destruction of any material evidence or document, etc., have been made penal and are subject to imposition of penalty. In this context, Mr. Chetia has argued that under the rule-making powers, under the rule-making power of the Act, the central government has framed the rules, making it obligatory for installation of CCTV camera covering all areas where packing machines are installed or manual process units are located within the factory. This is not relatable to any cess, but for confirmation and but for oversight and confirmation that right reporting is made for imposition of correct amount of cess from the manufacturer. The element of privacy does not come as an impediment in this power, where the CCTV surveillance is only in an area where packing machines are installed or manual process units are located in a factory. But for this provision, wrong reporting or tampering cannot be discerned. They cannot be discerned. On the contrary, assailing the provision as being unconstitutional, Mr. Saraf, however, has pointed out interim orders passed by two of the high courts, namely Allahabad High Court and Rajasthan High Court, where pending final consideration, it has been directed that till the next date of listing, no coercive measures may be adopted against the party concerned on account of non-compliance of Rule 33 of the rules.
Lordship, that
Just a
was.
minute. Based on these interim orders, Mr. Saraf has requested for similar kind of protection in the petitioner as well. We are not inclined to pass any such order for the reason that the penalty which would be imposed upon any manufacturer or dealer or any manufacturer would only be under situation of under circumstances of wrong reporting or failure to provide documents demanded by the officer undertaking an oversight. Undertaking an oversight. Even for interim protection, the matter is required to be heard. Let detailed counter affidavit on behalf of respondent number 2 and 3 be filed positively by the next date. Re-notify, give us the date. You want a short date, we will give a short date. You want a long date, we'll give a long date. You tell me, Mr. Saraf, because we have declined. We have said positively we have not declined, but we say that we don't consider.
Interim order at this stage, you'll also may at least observe that not finally at this stage, you'll also may.
उसको काट दो paragraph ही काट दो.
And
Let us
secondly,
do something for
and
this.
secondly, the observations which have been made earlier, that were the contention of my general friend, not the observation of the court.
No, we have said. Though it is our observation, but we have put it in his
I
mouth.
can understand, but
We have put it in his mouth.
otherwise
It is not our.
it will amount to the final.
No, it is not our.
I am becoming a victim of the non-speaking order passed by the other court.
No, we have.
I'm saying, with the difficulty there, the chief justice like which we have here, we don't find other places.
No, Mr. Saraf.
And that is the difficulty that we become victim because your OC passes speaking order, others will not bear. They don't pass the speaking order, simply interim order is passed. And today I am the victim of that.
It's so easy, no? Pass order without any reason.
No, that's why I become victim of that order.
Anyway, वो काट दो entry. He has prayed for an entry. This also requires to be adjudicated
On the next day.
on the next date. File counter affidavit. Well, we have removed that.
The interim order which has been referred to, that is not in respect of the present rule, that is the perimeter provisions of other rules, Lordship.
It is tobacco.
Lordship. Civil tobacco, Jordan.
Another order, 1136. Even the same
Two
order.
orders are there. One is tobacco and this is.
Specified instrument. We are not following that. Why you appear from?
Is it national security order 113?
Respond number? CGC. उनका भी नाम लिख देना. You also respond.
Union of India, Lordship.
Union of India shall also respond because it is by central government. No, the rules are by central government. Miss So and so, can I?
Burman, on behalf of Mrs. A. Guy,
What is your name?
M. Burman.
M. Burman. M. Burman. Learned advocate has appeared on behalf of respondent number 1 / Union of India. Counter affidavit on behalf of respondent number 1 be also filed by the next date. In these matters, the refrain of this court is that without hearing the other side, don't pass interim orders. That can have very, big cascading effect otherwise. Shouldn't. Anyway, we are not here to advise. But we follow the rules of housekeeping set by ourselves.
All right.
All right. Yes. Next is also same.
The only act and rules will be different, so I will give this.
List this matter along with this also and so on.
Because here the act will be the different, the provisions will be different, so it will be changed.
Necessary change. necessary change. All right, same. You accept notice, both of you accept notice.
Only things will change, no?
Only
Provisions of the act.
Same date we will take it.
And there is a specific penalty in this act, you know? I will,
No, no, then
give,
give the detail.
I will give you a slip of paper with the relevant provisions and act in the provisions, you know?
Now we'll get up for a while, after 6 weeks. 6 weeks. We'll come back in 5 minutes.
15 June. Item 23.
Yes,
Selling the armed force terminals about 15/8/2023. Or any, equally notice of issue where again 2024.
Yeah, we
In
will do
11,
this.
accordingly, steps have been taken and it is served upon the sole respondent. But today also they are not appearing.
एक chance और देता है. We'll give one more chance. But there was a closed head injury. Anyway, we'll see. Here. Despite service of notice on the respondent, nobody has appeared on his behalf. Giving one more opportunity to the respondent to contest this case. The matter is adjourned to July.
Hello.
31st July. 21/7. Item 24.
This particular matter notice was issued on 31/10/2025 with an interim order. My lord, can Mr. Senior Counsel, Mr. M.K. Chaudhary, it's showing in the reflecting the causes.
We just meet on my senior MK solution next.
As paid for on behalf of respondents.
Sole respondent.
So on behalf of respondent, on behalf of the sole respondent, a prayer for adjournment has been made on account of present unavailability of Mr. Chaudhary, the senior application who has to address this court. Let this matter come up for consideration on
Sometime in June, your chips.
June.
Interim order passed away, my kindly.
And that order, if any, in the meanwhile shall subsist, shall continue.
17th June.
Deeply obliged.
Item 25.
May I please, Lordship, I'm supposed to make a rejoinder affidavit in against the IA file. I seek.
Jurisdiction.
Yes.
Something has happened in head office in Delhi, you have been served in Tripura, you have filed it here.
Lord.
That's what Mr. Panik has said.
Now, Lordship.
I'm sorry, Mr. Dutt. I'm so
Mr.
sorry.
Datta.
Yes, both of you look alike. I don't know. I'm so sorry.
So
I don't think either of you would object to, that kind of confusion in the mind of the judge.
No, not at all.
But,
Both of you are good looking, so there is no difficulty.
No, my
The
prayer-
learned counsel for the petitioner seeks some time to respond, to file rejoinder affidavit. So let such an affidavit be filed positively by the next date. Over Mr. S. Datta, learned senior advocate, the present smart company.
Well, my friend says that if it is convenient to your lordship on 11th of May.
11th of May would be too early. 11th of May, I think, no, not 11th.
The
It has to
difficult,
go to June.
well, I am also out of employment.
18th of May.
18th of May.
Item 27.
My lord, 1 minute. My lord,
Payment of dues, Mr. Kumar, the same matter, 27th.
My lord, 18th Lordship, can there be 19th? I have some other.
19th,
Right.
all right, this was 19th of May, Kaddo. And this Manzoor Alam, Mr. B.D. Kumar, what is the name? You want when? Which letter? 29 July.
29 July was the other matter. Same day.
29th of July, here, order is coming. Yes.
29.
Obliged, sir.
Along with that.
Supplementary list. Item 29.
Legal Lordship. Contractor counsel is not available today, Lordship. Mr. Kala was in Supreme Court, Lordship. Maybe adjourn for that day.
As straightforward on behalf of the appellate, let this matter come up for consideration on Monday.
Yes, Lordship. Obliged.
Oh, yeah.
Yes.